Hi, my name's Campbell Dumont, and the case I chose for my second case presentation was Strickland v. Washington, 466 U.S. 668, and it was decided in 1984. Oops. The facts are as follows. David Leroy Washington went on a violent crime spree in Florida, murdering 3 people and partaking in other felonies such as assault, kidnapping, and theft. The crime spree lasted 10 days and occurred in 3 criminal episodes. Upon arrest, he confessed to the crimes included in the 3rd criminal episode. He was accordingly indicted for kidnapping and murder and appointed a lawyer. Against the advice of counsel, Washington further confessed to the first 2 murders. Washington once again ignored counsel's advice in waiving his right to a jury trial and pleading guilty to all charges. At this time, his counsel described having a feeling of hopelessness after the additional 2 confessions and his decision to waive a right to a jury trial and plead guilty to all crimes. In Washington's plea colloquy, he took full responsibility for his crimes, yet cited having been under significant mental strain due to his inability to provide for his family, along with him possessing no significant criminal record. Washington once again ignored legal advice to invoke his right for an advisory jury at his sentencing hearing. He chose to be sentenced by the trial judge without jury advisement. Facts Part 3. At the sentencing hearing, Washington's counsel did not present any character witnesses or call for a psych evaluation. Instead, he relied solely on the plea colloquy. Finding numerous aggravating circumstances and insufficient mitigating circumstances to outweigh them, Washington was sentenced to death. Washington obtained new counsel who contended that he had received ineffective counsel at his sentencing hearing. That claim was rejected first by the trial court and then by the Florida Supreme Court. Federal habeas corpus proceedings began, with the district court finding against Washington. Next, the 11th Circuit Court remanded or sent the case back to district court with a new legal standard. And the legal standard they came upon for reasonable counsel or effective counsel is as follows. Counsel reasonably likely to render and rendering reasonably effective assistance given the totality of circumstances. So this was very vague, but Strickland, the warden at the prison Washington was being held, successfully petitioned the United States Supreme Court. This case has to do with the 6th Amendment, so I put up the 6th Amendment if you'd like a little refresher. We're especially going to hone in on that very last clause, and to have the assistance of counsel for his defense. So these were the arguments. On Strickland's side, they asserted that Washington's counsel strategically excluded the psych evaluation and character witnesses. This is because if he included a psych evaluation or his own psychiatric expert, then the state would have included their own psychiatric expert, and as his attorney, through his conversations with him, he saw no signs that Washington was mentally ill or nothing to point that he had had some psychotic break. Mr. Washington had also already undergone a psych evaluation 6 days after his arrest that found although he was depressed and under a lot of pressure, his conduct was not indicative of any sort of mental health episode. He did not include character witnesses because if he included character witnesses, then the state would have included the fact that Mr. Washington did have a significant criminal history. Mr. Washington had said to the judge in his plea colloquy that he didn't, and that was just simply false. He didn't have a violent criminal history, but he did have a criminal history of theft and burglary on multiple counts. And thirdly, this judge was known for really respecting and being lenient to those who showed responsibility for their crimes and remorse for their crimes. So Washington's attorney chose to just really focus on Washington took full responsibility and was quite remorseful for his crimes. The state of Florida is also going to point out that even if his attorney erroneously failed to support the mitigating factors, this mistake would not have affected the outcome of the sentencing hearing. Therefore, it does not meet the standards for prejudice. There was just too many aggravating factors and not enough mitigating factors that even had these mitigating factors been factually supported or evidence had been to support them in any way, it wouldn't have been enough to outweigh the very many aggravating circumstances. Washington is going to obviously argue something very different. He's going to say counsel's lack of investigation left him unprepared for his sentencing hearing where he was sentenced to death. The attorney's sense of hopelessness explains why he failed to perform his duty by including a psychiatric evaluation and character witnesses. The attorney's actions or lack thereof impaired Washington's defense. He's also going to make a very interesting argument that prejudice should rely on impairment to the defense and not effect on outcome. And this is because the outcome determinative model assumes that a defendant could have a fair trial with incompetent counsel. The legal question in this case is what standards should be applied to determine whether a convicted person's Sixth Amendment right to counsel has been violated as to require reversal of a conviction or penalty imposed. Findings. In an 8-1 decision, the Supreme Court found in favor of Strickland. The majority opinion was penned by Justice O'Connor. The Sixth Amendment's assistant clause is fundamental in providing a fair trial to criminal defendants. This clause implies that providing counsel is not enough to legitimize our adversarial criminal justice system. Due to its adversarial nature, counsel must be competent and able to help the criminal defendant navigate the system. Justice O'Connor also pointed out that we were in uncharted territory as the Supreme Court had focused since Gideon on access to counsel, not quality. The standards for competency of counsel have yet to be defined. So she's going to try to define them. Introducing the Strickland test. To prove ineffective assistance of counsel, a defendant must show, first, their lawyer's performance fell below an objective standard of reasonableness, and two, that there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceedings would have been different. For counsel to be proved ineffective, both parts of the test must be met. So these terms seem incredibly vague. How did Justice O'Connor come to these criteria? First, the objective standard of reasonableness is based on the fact that law is highly subjective. It's an art, not a science, and it's dependent on individual lawyers to decide which strategy to use and which precedents to rely on. Second, there's an inherent value of hindsight that can't be overlooked. Even the most skilled criminal defense attorney may look back on a trial and say, I shouldn't have done that, or I was mistaken when I did Y. But that doesn't mean that he provided inadequate counsel. Thirdly, there needs to be a wide deference to attorneys due to the subjective nature of law, and also so attorneys are encouraged to avidly defend their clients and be creative in the defense of their clients. If it's a checklist that in order to be adequate counsel, you must do A, B, C, and D, then attorneys may be limited in just doing that and may not seek out all avenues to defend their client. In terms of the second part, there is reasonable probability that but for counsel's unprofessional error, the result of the proceeding would have been different. The court did not buy Washington's argument that it should be based on impairment to the defense, because the court is going to say in their majority opinion, doesn't every error impair the defense? If you followed on impairment of the defense, then there would be many cases where the attorney would have made an error and the law would have, and the conviction would have to be vacated or the penalty would have had to have been reversed. And there is a need for finality of law that this standard just wouldn't be compatible with. Thus, in order to give a fair trial, this error has to have likely affected the outcome. If this error wasn't committed, there has to be a likely chance that a different outcome would have been obtained. And now she's going to apply this test to the Strickland case itself. She does buy Strickland's argument that this was strategic to focus on remorse, given the totality of circumstances, that he did have a significant criminal record, that a psych evaluation had already been obtained and failed to show that he had any sort of psychotic episode. That is why he avoided including character witnesses and the psych evaluation, and they found that to be compelling. It's unlikely that these possible mitigating circumstances would have outweighed the aggravating circumstances, so to get life in prison instead of the death penalty. There were numerous aggravating circumstances, such as the brutality of the crimes, the fact that the crimes had the goal of pecuniary gain because he stole the wallets and other valuables off of the people who had been brutally stabbed. Due to this, it's unlikely that it would have satisfied either of the clauses in the Strickland test. In a concurring opinion written by Justice Brennan that concurred in part and dissented in part, he dissented with the court's judgment because the death penalty, in his view, is cruel and unusual. And so the death penalty as the sentence should have been vacated for life in prison. He agrees with the test. In fact, he believes that it gives lower courts a guide to judging effective counsel. The test does not limit attorneys or discourage them from investigating mitigating factors. Special care, though, should be taken when applying the test to capital punishment sentencing due to the severity. There was one lone dissent by Justice Marshall, who said, "My objection to the performance standard adopted by the court is that it is so malleable that in practice it will either have no grip at all or will yield excessive variation in the manner in which the Sixth Amendment is interpreted and applied by different courts." He's going to call for a more uniform standard and argue that lawyers don't need as wide a latitude. A more checklist model is acceptable. Prejudice cannot just be based off of outcome, because procedural fairness needs to have an inherent value. This also puts a great burden on criminal defendants to prove ineffective counsel, especially important regarding capital sentencing, that there was only error, not that the error would have likely affected the outcome. Washington's attorney had failed to fully investigate and produce significant possible mitigating factors, such as societal ties. There were many people who would have been character witnesses to him, for him in his society, in his community, who his lawyer declined to speak to. This failure alone, regardless of the probability of a differing sentencing outcome, should have rendered counsel ineffective. Since Strickland. So the Strickland test remains the criteria for deciding if criminal defendants' Sixth Amendment right to counsel is violated by ineffective counsel. It remains overly vague with an unclear application. Due to that, there's been two cases particularly that have revisited Strickland in a way. Wiggins v. Smith in 2002. In this case, the criminal defendant had suffered horrendous abuse. His attorney failed to investigate his background and present the mitigating evidence of his life history. This was ruled as ineffective counsel and met the requirements of the Strickland test. Second, Primo v. Moore. In this case, the court found that it is not ineffective counsel when a lawyer fails to attempt suppressing a client's confession before the client has pleaded no contest to murder. And this was a unanimous decision and attempted to show how to apply Strickland. My question during this was Strickland v. Washington the right case to establish tests for ineffective counsel? I do agree that the ineffective counsel test is very vague, but I do believe the basis of it has a really strong foundation, and there's a reason for the vagueness of it. However, Strickland v. Washington, to me, seems like a very cut and dry case. On the surface, it seems like it would be clearly inefficient counsel because he provided no mitigating factors or provided no evidence for mitigating factors. But once you actually listen to why he did so, it becomes clearly evident that he did provide effective counsel. So I think a case with more ambiguity should have been used, and the standard should have been born out of that case. Oh, one sec. Ooh, wait, I didn't show you. Sorry, I have to show you my works cited. Oh, this is my works cited page.